We last left off where we were discussing the statute of frauds and the rules that apply to the statute of frauds and when they apply. And remember, for purposes of our exams, you're going to be responsible for knowing the real estate rule, the 1 year rule, as well as the merchant sale of goods in excess of $500 rule. We're going to move on to third-party rights in a contract. Generally speaking, you may remember when we first couple of weeks of class, we discussed some very basic principles of litigation, including the idea that the person suing must have standing, legal standing in the lawsuit for them to bring the lawsuit. And of course I had my little quirky, silly examples about me being hurt by the McDonald's hot coffee and you feeling badly for me and suing on my behalf or suing for me, and of course you not being able to pursue that because you lack standing since the thing didn't happen to you. Well, in contract law, we have something similar to that, and it's known as privity of contract. And privity of contract means that in order for you to pursue your rights, you have to stand in privity of contract or actually have a stake in the outcome of the particular contract in question. And there are a couple of exceptions to that, and that's what we're going to discuss here on slide number 10. The first exception is where a party to a contract has legally assigned their rights in the contract to a second party. And assuming that assignment is legal, then the assignee of those rights may then pursue whatever those rights are in a subsequent lawsuit. Now, there's a very important caveat there, and the caveat is assuming it is legal. And the general rule is that you can assign, it is okay, it is legal to assign your rights in a contract. However, in the real world, it is often, in a contract, there will often be a provision that prohibits an assignment. For example, let's say that you lease an apartment. That lease will not allow you to assign your rights in the lease to someone else. You may do that, you may sublease it. More than likely it'll be in violation of the lease unless you get the permission of the landlord first. Assuming, however, that the assignment is legal, then the assignee of the rights, the party to whom you have assigned those rights, would have standing to pursue those rights and would be in privity of contract. The second exception I want to discuss is involving a third-party beneficiary contract. And a third-party beneficiary contract is a very specific type of contract in which work may be done and there may be parties to a contract, but it be designed for the primary benefit of someone else. What in the world does that mean? Well, in practice, it's not nearly as difficult as the definition. Let's say that you hired a contractor to build a house for you. Well, the building contractor doesn't do everything. He may do the electrical, or he may do the plumbing or the framing, but he's not going to do the painting, and he may not do the plumbing. And he's going to hire his own subcontractors to do that part of the work so that he can fulfill his obligations to you. Well, what happens if he hires painters and pays the painters, and the painters run off and leave? Well, now you've got a house, and hopefully the house is finished, but it's not painted. And you try to sue the general contractor, and maybe the general contractor has died or otherwise gone away, filed bankruptcy, went out of business, whatever. And you want these painters who have been paid to do what they're obligated to do. Well, if you sue the painters directly, you don't have a contract with them. You're not in privity of contract unless an exception applies. And this is the exception. This is the model third-party beneficiary contract where the painter's work was designed to benefit a third party, being you, of course. And because of that, you will be given the rights and stand in privity of contract so that you can pursue whatever rights are under the contract. Slide 11 mentions a couple of other potential assignments that may or may not be assignable. Workers' compensation benefits, generally speaking, are not assignable. Why? Because the law says they're not assignable. Common law, if a contract is personal in nature, personal services contract, for example, then it generally cannot be assigned. Let's say that you hire Nick Saban to coach the University of Alabama football program. And Nick says, well, I want to take that $10 million a year that you're paying me, but I'm not really in the mood to coach football anymore. I just want to go to my lake house in Georgia and sit back, kick back, and relax. But I do like that $10 million a year coming in. Hey, Cartwright, you've always wanted to coach football. How about if I split it with you 50-50? You coach the team, I'll pay you $5 million of the $10 million they pay me. I'm going to assign you my rights in the contract to collect the whole $10 million. You just do what my job was, and then you kick back $5 million of it to me. Do you think that Alabama would be happy with me coaching their football team? Odds are not very much. And the law kind of recognizes situations like this. They said that the services in nature here are personal, and because of that, they are not assignable without the consent of the other party. And you can think of a lot of other examples that aren't quite as far out like that. If the assignment would materially increase or alter the risk or duties, let's say that I owe money to the bank, and for some reason or another I take that contract that I have with the bank and I assign my rights in it, and I find somebody even less creditworthy than me. Well, the bank doesn't have to abide by that assignment because it might materially increase their risk of loss in that situation. And those kind of contracts are not assignable. Now, it's going to be important for you to know the difference between an assignment and a delegation. These are similar concepts, but they have vastly different legal consequences. We've discussed assignment. A delegation is where you transfer your duties under the contract to someone else, but you are not relieved of your obligation to fulfill that contract. It's basically like you're subletting your apartment to someone without the landlord's permission. What happens when you've got a year-long contract, a year-long lease, and you're not going to be there for the summer? And so you sublet it to someone else for the 3 months of the summer. You say, hey, you just go ahead and pay those 3 months, and it's your apartment for the summer. I'll see you in the fall, and I'll take it back over. What happens when they don't pay the landlord? Who do you think is still on the hook to pay the lease? That's right, you are still on the hook to pay the lease. And the reason is because you have delegated your duty. You have not assigned your rights, duties, and responsibilities. If the lease allowed you to assign it, then you could say, okay, I'm assigning you my rights, duties, and responsibilities under this lease agreement, and then if he didn't pay the summer rent, it'd be on him and not on you. But that would be very unusual because every lease that I've ever read always prohibits the assignment of a lease without the express written consent of the landlord. Don't get caught up in the difference between intended beneficiaries or incidental beneficiaries. As long as you know the basics of a third-party beneficiary contract as discussed a few minutes ago, I will be fine with that, and you'll be fine for purposes of the test. Obviously, how else can you get relief from your obligations under a contract? Well, if you perform. If you agree to sell me 10 tons of gravel for $1,000 and I pay you $1,000, then I have fully performed, and so I'm discharged from my obligations under the contract. Or conversely, if you have delivered the 20 tons of gravel, then you have fully performed and you're discharged from any further obligations under the contract, and you can pursue me for paying you what I owe you. In addition, there's a concept in the law that says one breach excuses another. And that is that if one party materially breaches the contract, then that discharges the other party from an obligation to perform. What does that mean? Give me an example of that, Mr. Cartwright. Okay, here's your example. Let's say that you agree to deliver 20 tons of gravel to me by Friday. I agree to pay you the following Friday, a week later after delivery. You don't deliver on Friday. You can't deliver on Friday, but the next Friday you're saying, "Where's my money?" Well, I don't have to pay you because you have breached the contract. It's a material breach in that, let's pretend that I was opening up something where I needed that gravel for a parking lot for that weekend and that weekend only. Well, time was of the essence, and as a result, you have materially breached the contract by delaying. I no longer have to pay. I'm discharged from my duties. Agreement of the parties. The contract's an agreement. We discussed this some time ago. And so whatever the parties agree to ultimately is what they agree to. So if I tell you and you tell me that we can each just walk away with what we've done and what we've paid, regardless of what the contract says, we can do so. We're relieved from the performance there. Operation of law. There are certain things that would discharge duties, such as filing bankruptcy may discharge duties, etc. Conditions. I agree to purchase 20 tons of gravel from you, provided that the state of Alabama awards the Special Olympics contract to me for concessions. If they do so on Friday, I agree to purchase my 20 tons of gravel from you. If the state of Alabama does not award me that contract to sell concessions at the Special Olympics, then that condition has not been fulfilled, and as a result, I'm not obligated to purchase the gravel from you. Don't worry too much about whether it's a condition precedent, condition subsequent, or a condition concurrent. And the last thing that I want to discuss for this one, and I may pick it up at the next one as well, is the idea of a material breach. Actually, I think I'll leave that for the next one. That's all that I have for this portion. Thank you.